5 seconds. Start. Firstly, we will deal with the contention regarding maintainability of this latter's patent appeal full stop. Learning Counsel for the respondents urged that earlier writ petitions challenging the orders passed in proceedings under the Public Premises Act were being entertained by the division bench, and after the decision of full bench of this court, they are now being placed before the single judge full stop. He contended that if the appeal is entertained from orders passed by the learned single judge in such petitions, then the object of amending rules for hearing of such petitions by the single judge for expeditious disposal will be lost full stop. Learning Counsel for appellants, on the other hand, has drawn our attention to the memo of the petition and the impugned order of the learned single judge, wherein it is mentioned that the petition is filed and was entertained under the Constitution of India and contended that the appeal is maintainable. It is true that the petitions arising out of the order passed under the Public Premises Act were being heard by the division bench full stop. The full bench found that the Bombay High Court appellant side rules were wide enough to include orders passed by any quasi judicial authority under any enactment full stop. The full bench found that the order passed by quasi judicial authority under the Public Premises Act is also covered by rules, and such orders are to be heard and decided by the single judge full stop. Reference was accordingly disposed of by the full bench full stop. The full bench held that the appellant side rules as they stand provide that the petitions challenging the orders passed under the Public Premises Act are required to be heard by the learned single judge, and therefore the observations made were not correct full stop. The petitions relating to orders passed under Public Premises Act were being entertained by the division bench when the rules provided that they should be entertained by the single judge full stop. Therefore, there was no conscious decision to remove the petitions arising from orders passed under the public premises from division bench and to place them before single judge full stop. In fact, full bench found that these petitions was being wrongly entertained by the division bench full stop. In the judgment of the full bench, there is no indication that letters patent appeal arising out of the orders passed by the single judge is proceeding under the Public Premises Act will not be maintainable